I want to welcome all of you to what is probably a Darwinian moment, and that is you represent the survival of the fittest after a very long and excellent day and a half program. The topic today is beyond the written opinion when justices speak to the public, and I'm reminded, and I'll be very brief about this, of two major Supreme Court cases. In McCulloch v. Maryland, besides Chief Justice Marshall's famous statement to the effect that it is a Constitution we are expounding, in that very same paragraph he said, it is very important for the people to understand the Constitution. And then, in what is, in my view, the most important Supreme Court decision of the 20th century, Brown against Board of Education. It is notable for many things, of course, but one thing in particular sticks out in my mind, and that is the relative absence of legal jargon. That opinion was written for the public at large and not just for us lawyer and law student types. So with that in mind, we are going to be hearing from three people dealing with, in a very real sense, the educational function of the United States Supreme Court. And our first speaker is Jason Mazzone, who's professor at University of Illinois Law School.
Great, thank you. So I think I'll just, I guess I'll just sit here. It's probably a little risky to ask a provocative, difficult question just before you appear on a panel. But the paper that I'm working on looks at appearances of Supreme Court justices before congressional committees in connection with the court's annual budget request. So the Supreme Court, as you may know, has its own budget, separate from that of the rest of the federal judiciary, that it prepares the budget and submits it to Congress for approval. And in connection with that budget request, the justices show up before the House Appropriations Committee and sometimes also the analogous Senate Committee to justify and explain why they need the money that they're asking for. Chief Justice Taft was the first of the justices to testify in this way before an Appropriations Committee in 1923 and then again in 1926. And since 1943, there's been annual testimony, and today it's typically from two justices. So in the paper, I'm looking at the exchanges that occur between the committee members and the justices, and this is just about the only instance in which Supreme Court justices on a regular and predictable basis make themselves available to answer questions from members of the legislative branch. So I gathered all of the transcripts from these hearings and read them all in order. And before I started the project, I was a little pessimistic. I predicted that these hearings would be similar to the confirmation hearings, which we've heard about already today, with a lot of grandstanding by the committee members and then unrevealing answers by the justices until the clock runs out and everybody goes home. Instead, these are actually remarkably rich and informative hearings. The questions, for the most part, that the committee members ask are on point and sensible. There's relatively little grandstanding, at least until you get to Bush versus Gore, after which everyone sort of lets loose. But until that point, there's relatively little criticism of particular court decisions. And even better, the answers that the justices give to the questions are surprisingly comprehensive and candid. One thing that is apparent throughout the entire period of these hearings is that the justices are very much engaged in the operation of the court as an institution, and they deal with all kinds of issues, including who's working at the court, how much they're getting paid, issues related to what is in the library collection, do they have sufficient books, questions of how opinions are issued and printed, the things that we've been talking about today, issues related to access by the public to the court, how visitors are going to enter the building, what they can see when they come to the court, security issues, and technology issues as well. Justice Thomas, by the way, and I say this in response to our first panel, Justice Thomas is really the technology guy at the court, so this was a little surprising, I guess. And it might explain why he's also the justice who appears most frequently before these committees. I think he's been there something like 19 times now. Before that, the record holder was Justice Black, a former senator. It makes sense that you would send him. One also gets the real sense from these hearings that the Supreme Court building is a real money pit Like many buildings from the 1930s, it looks nice from the outside, but inside the infrastructure, at least according to the transcripts, is really poor. So beginning in the 1950s, things are falling apart, and every year there's some new infrastructure issue that requires funding from Congress and the attention of the justices. So the air conditioning isn't working, and the telephone system isn't working. There are all kinds of wiring problems. In the modern period, as you may recall a few years ago, the building is literally falling down. A big piece of the facade falls down, and they have a modernization process going on. But what's interesting is that the justices themselves are involved with contractors and complaining about the delays and the contractors coming and figuring out how to upgrade the systems and so on. And just to give you one quick example, in 1959, there's a big problem with migratory birds going to the bathroom on the marble on one side of the building. And the justices come to Congress and say, we've tried putting up netting, but that's not working, and we want to install this electronic deterrent system, and there's a request for funding for this, so many thousands of dollars. And the House says, sounds like a good idea, but if you scare the birds away from the Supreme Court, where are they going to end up? We know where, the Capitol. And so deny the request. The justices are also quite conservative with respect to their budget requests. So the court's budget certainly grows year by year, and it's up to about $80 million per year now. But there seems to be a pretty firm understanding that the court will only ask for what it really needs. And while Congress doesn't always give the court everything that it asks for, the assumption is that there really isn't any fat. And so repeatedly in these hearings, the committee members will say to the Supreme Court, you're not like all these other federal agencies that come to us with these bloated requests. We appreciate that, which gives the court, I think, a great deal of credibility when it does ask for increased funding. And this relates to a further point, which is that the participants in these hearings, the committee members and the justices, are aware in the background of the potential separation of powers issue that is presented by the court's dependents to the tune today of $80 million on the legislative branch. So frequently these hearings will begin with the committee chair saying, we're a little uncomfortable with the justices having to testify before Congress like this. And then the justice is saying, no, it's okay. It's good to have this sort of inter-branch dialogue. And this sort of sets the stage for the rest of the hearing, in which the committee members, I think, understand that they need to be respectful towards the justices. But the justices understand also if it wanted to, Congress could yank the money, and we won't get the new photocopier if we're obtuse. And so it seems to me that this produces a pretty healthy dynamic in which it's relatively rare for a question to be asked, to which the justices respond, I can't answer that because it's an issue that might come before the court, right? The most repeated line from the confirmation hearings. And at the same time, you do get a great deal of information about the court's work and the justices' thinking. And in that respect, I wanted to switch then from sort of some general comments to tell you about one particular issue that I'm exploring in the paper involving some cases, and that's the court's federalism decisions in Lopez and Morrison. These cases are never mentioned by name in any of these transcripts, but the hearings gave me some new insight in what the court was doing in those cases. So a constant issue throughout the entire period of these hearings is the court's workload, and the growing workload is the basis for the court requesting additional resources, more law clerks, more secretaries, more support staff, and so on. And in the context of these requests, the committee members are always asking the members of the Supreme Court, well, are there ways to reduce the number of cases that are coming to the court? I guess that's another way of dealing with the resource problem. And this opens up a really very interesting dialogue between the court and the committee, and indeed I would say Congress and the general public, about the jurisdiction of the Supreme Court, as well as about the jurisdiction of the lower courts, which are feeding cases to the Supreme Court. So in the early 1980s, the justices are asking, pressing really, for broad cert powers and to get rid of mandatory appeals. And they also press for some other changes with respect to the kinds of cases that they are being asked to hear. And Justice O'Connor is really the leader here. She appears before the committee in the House beginning in 1982. And in addition to wanting the committee to eliminate mandatory appeals, she wants Congress to get rid of diversity jurisdiction altogether, to create a separate court that would resolve conflicts among the circuit courts rather than having those cases decided by the Supreme Court. O'Connor appears with Justice Powell in the early 1980s, and they really have their act down. So Powell, after O'Connor makes her spiel, advocates also limiting habeas cases to claims of actual innocence, thinks that that's extent of habeas that's required, requiring exhaustion of state court and administrative remedies before any kind of 1983 case can be decided. And the justices present these arguments in terms of the increasing caseload that the Supreme Court itself is facing, but also in terms of the burden on the lower courts. And they're remarkably protective of the lower courts in this period. So Congress does give the Supreme Court expanded cert powers in 1988. In 1989, O'Connor is back before the committee, and she says, "Oh, thank you very much for that." But now she's there with Scalia, and they have two new complaints. And these are really on behalf of the lower court. So one is, and this will lead into Lopez and Morrison. One is the impact of the new sentencing guidelines on the circuit courts, because now every sentence imposed by a district court clerk is creating an appellate issue that is going to have to be decided by the circuit court. And then two, and this is the really big one, the increase in federal criminal laws in this period, particularly drug cases. And they tell the committee that they're very concerned that because of what Congress is doing, federalizing all of these crimes, the lower courts are getting clogged up, as Scalia puts it, or as O'Connor says, quote, overwhelmed with criminal cases almost to the exclusion of opportunities to hear civil cases. And in the next few years, Scalia and O'Connor and other justices who appear before the committees raise constantly this concern about the new set courts must hear. Now, hindsight is 2020, but when you read Scalia and O'Connor and other justices, read what they're saying in the early 1990s to the committee. They're forecasting Lopez and Morrison. So here's Scalia in 1991 says, "I'm sure that Congress doesn't create new causes of action unthinkingly, but I hope you don't mind being reminded now and then that there really is a limit to what the federal court system can bear without altering its character. In the past, we have sort of had an understanding that local crime was for the states." O'Connor the next year, "The effect of making federal offenses out of a larger and larger share of what traditionally has been handled in state courts is going to have a deleterious effect on the federal court system as a whole. It already has, and there seems to be no end to new federal legislation that is taking very traditional sorts of criminal offenses and making them federal offenses as well. This is an unfortunate trend in my personal view." And they're spinning this issue not about Congress getting grabby, but about the impact of federalization on the federal judiciary as a whole. And Scalia in 1992 tells the committee that Congress is turning the lower federal courts into what he calls police court judges. He says it isn't what they signed up to be, and it diminishes the prestige of the federal judiciary. You're not going to be able to recruit the kind of high-minded people who can deal with things like antitrust if you give them these kinds of cases. Five? Okay. Yeah. And the justices are also saying that this is an issue of fairness for litigants. And so this is a constant theme that these new cases being thrust upon them by Congress are pushing aside other kinds of federal claims that the courts used to be able to hear. And I say forecasting both Lopez and Morrison, I've talked so far about criminal cases. Morrison involves a civil cause of action. So Scalia in 92 says, the problem is not just the criminal cases, it's some civil matters too, which are really too trivial to be handled in federal courts. It takes discipline to say, well, yes, we could show our compassion in this or that area by creating a new federal cause of action, but it's going to hurt all these other people who are now trying to get into federal court. And the House committee at one point asked Scalia and O'Connor, what criteria should Congress use in thinking about whether to federalize something? And they have the same answer. If it's been traditionally the domain of the states, leave it alone. Scalia, of course, joined the majority in Lopez in 1995, finding that there's no sufficient federal connection to sustain the Gun-Free School Zones Act. Justice Kennedy is an interesting case in this period. So he's before the Senate committee March 3rd, 1994, so this is right before Lopez, and he tells them this. He says, when you have a proposal that makes it a federal crime to carry a handgun in the committing of a crime, you have serious systemic consequences that result. You're going to have a very substantial substantial increase in U.S. attorneys' offices and in U.S. judges. We do see some very serious concerns just from the standpoint of keeping the character of the federal judicial system if you begin to add on police duties, right, adopting this idea from Scalia about police judges. On the other hand, he also says it's not up to us, the court, to police the boundaries of federalism. He says we do that in the areas of separation of powers, but we leave it really to you, Congress, to exercise discretion and restraint. Now, Kennedy, of course, is also next year in the majority in Lopez, so perhaps he just changed his mind about the role of the courts. But I think there's another way to understand Lopez and Morrison in light of Kennedy's statement, and in light also of what the other justices are telling the committee in these years. So expanding the jurisdiction of the federal courts in the way that the statutes that Lopez and Morrison did raise, yes, federalism questions, and we read these cases in federalism terms, but they also raise, I think, separation of powers questions, right? The thing that Kennedy tells the committee that the court can police. So the separation of powers issue is that Congress is altering the traditional role of the federal judiciary, undermining its prestige, burdening it with cases that could and should be decided elsewhere, disincentivizing people to become judges, and doing all of this without giving the court sufficient resources to get the job done. So the statutes in Lopez and Morrison from this perspective are problematic, not just from the perspective of federal-state relations, but problematic also if you are concerned about docket control, about the impact upon the federal courts and the lower courts in particular. And framed in this way, the justices who are often called the liberal justices, including Scalia, sign on to this concern. They don't sign on to Lopez, but when Souter appears, for example, in 2000, he's very strongly opinionated about this problem of increased federalization and says the criterion ought to be basically, is federal protection needed because state prosecution for any number of reasons is going to prove itself ineffective, right? And when Kennedy's back before the committee, right after Lopez, he has to explain how is it that you told us one thing and then did something else, and he says, well, in large part, the federal balance is remitted to the Congress. In large part, might be understood, I think, to mean that where there is special separation of powers, where the court as an institution has a particular concern with what is happening with the docket, then this is an area where the court should involve itself. So that's the idea. One idea that I want to advance from all of this, Lopez and Morrison as docket control or even separation of powers cases rather than just as federalism cases. There's a lot more in these transcripts, cameras in the courtrooms, minority law clerks, recusal, and lots of other stuff. I wanted to end just with a little nugget that was inspired by the conversation this morning about the justices being sort of anti-technology or slow with respect to technology. In 1978, the justices want $90,000 to install computers, Wang computers, in all of the chambers. And Powell is there testifying about these computers, and they're asking him, what do they do? Why do you need them? And he tells the committee, you have to come and see these things. You have to come see them for yourself to see what they do. He says, quote, the law clerks have learned to use the new system. I don't understand it at all, but you have the equivalent of a television screen as you type. And we have this thing that looks like a typewriter. You type, and it projects immediately what is typed on the television screen. Then there is a storage unit that stores what you type. All right, so so maybe they're sort of a little behind, but clearly today we do have some progress. So thank you.
Thank you, Jason. Our second speaker is Jeffery Rosen, who's professor at GW Law School and legal affairs editor of the New Republic, and we welcome Jeffery back for the second time in about a month or so. Thank you.
Thank you so much. I'm delighted to be back for the second time in a month. I was here a few months ago for a wonderful privacy and technology conference, and I was so happy when Carolyn and Christopher asked me back. I'm very impressed with the things you're doing at Chicago Kent, and I'm much looking forward to this conversation about one of my favorite topics. What are the justices trying to achieve when they address the public outside their written opinions? So obviously, the justices are trying to achieve all sorts of different things in different contexts. Sometimes, as Jason just explained so astutely, they want money. They can want money from Congress, or now that they're promoting books and getting serious advances for them in the past couple of years, they're sometimes trying to promote their books. Other times they want to promote civics education, as when they talk to school kids. But sometimes, not all that often, they decide to talk to journalists. And I've had the great good fortune over the 20 years or so that I've been writing about the court to have a few interviews with various justices. And I'm glad to have this opportunity to reflect on the question, why did they sit down with me? What were they trying to achieve? And was it a good idea in the end from their perspective? So in a kind of dinner party spirit, I'll just tell you about my dinners with a few of the justices and give you some observations. There's nothing systematic about it. I think each of them were trying to achieve different things at different times, but they were certainly fascinating experiences for me. So I guess the most recent extended one, and in some ways the most illuminating for me, was the interview that Chief Justice Roberts gave to me at the end of his first term as Chief Justice. He had just finished his first term. I was writing a companion book to a PBS series on the court. Roberts, it turns out, is a PBS fan and wanted to support the series. And we had had some encounters before where I'd written about him, and I guess he was not unhappy with those articles. So as a result, he sat down with me. I didn't quite know what to expect in this interview, but it turned out to be quite an extended conversation of, I don't know, 2.5, 3 hours, where he set out his vision of the kind of Chief Justice he wanted to be. And he was very explicit about his goals. He said he was frustrated that his colleagues were acting more like law professors than members of a collegial court. He said, apologies to you, Professor Rosen, but law professors have made some terrible justices over the course of history. They're too theoretical, they're too academic, but most important, they're too wedded to their own pet ideological theories and less concerned about the institutional legitimacy of the court. And Roberts said he thought it was bad for the court and bad for the country when the justices divided 5-4 along partisan lines, 5 Republicans against 4 Democrats. He said it was important for the court to stand for something larger, something that citizens of different political persuasions could accept as being rooted in law rather than in politics. And he said that he was going to make it his mission as Chief Justice to try to persuade his colleagues to put aside their own ideological agendas and to make institutional legitimacy a concern in almost every decision the court reached. He would try to do this by trying to persuade them to converge around narrow, unanimous opinions that avoided broad constitutional rulings and often decided things on more technical grounds. He recognized the difficulty of his task. He said, it's striking to think that out of my predecessors as Chief Justice, more than half have been failures in achieving consensus, but he thought it was very important, and he was quite passionate about this goal. All right, I was very impressed by Chief Justice Roberts in this interview. Some people thought I was too impressed. My wife decided that I developed a man crush on Chief Justice Roberts, which is completely false, I assure you. But I was rooting for him, and imagine my surprise when, like many people, I watched the court over the next couple of terms issue a series of very polarizing 5-4 decisions. The term after we talked was the term of Wisconsin right to life, the first campaign finance case, and the partial birth abortion case, and parents involved the affirmative action case. 33% 5-4 decisions. The justices are sniping at each other in personal terms. Justice Scalia accuses Roberts of faux judicial restraint, which I guess is the nastiest thing he's ever said on the Supreme Court, faux judicial restraint. And basically, there was a lot of criticism from the left and kind of delight from the right that Roberts, far from being a uniter rather than a divider, in fact, was presiding over a very partisan court. And then came Citizens United, which made things worse. And then came the Affordable Care Act decision. And in the months leading up to the argument, there was widespread expectation that the court would strike the Affordable Care Act down 5-4. And we now know from reporting by Jan Greenberg and others that, in fact, Roberts did initially vote to strike down the act, at least under the Commerce Clause. It's not clear whether he cast an initial vote about the taxing power, but that at some point in May, he changed his vote and voted to uphold the act under the taxing power. Around mid-May, an article appeared by George Will, which noted that Roberts was being pressured to uphold the act by liberals, including Pat Leahy and, of all people, me. And Will said that by noting, Leahy and I, that Roberts had once pledged to avoid 5-4 decisions, we were pressuring and trying to intimidate him, and Will called on him to show a steel of spine and not to buckle to this pressure. Now, I thought I was stating the bleedingly obvious by saying that if you strike down the Affordable Care Act by a 5-4 vote, then you've failed in your stated goals of avoiding striking down laws by 5-4 votes. And regardless, I can't imagine that Chief Justice Roberts would care in the least about the commentary of any journalist, or let alone a senator or even President Obama. But I have to say, I won't say whether I was surprised or not. There was Kimberly, you said you predicted the morning before or something like that. The morning of, I had said it's not going to be 5-4, striking it down. I'm not sure I thought it was going to be Roberts alone upholding it. I thought Kennedy was more likely, but my prediction doesn't matter. When I go back and read the transcript of that extended interview, I'm struck by how in the Affordable Care Act decision, Roberts did exactly what he said he would do. He said, I hope that it will be said of me when people go back and look at my decisions that all of them show a concern about institutional legitimacy. He said, I think that's the special role of the Chief Justice. I might act differently if I were an Associate Justice, but my job is to preserve the long-term legitimacy of the court. In this sense, he wasn't crudely following the polls. The mandate, as it happens, was unpopular with a majority of Republicans and Democrats when the case was decided, although Democrats, interestingly, came to rally around the mandate, as Nathan Persily has shown, after the court upheld it in a kind of validation effect. But I think Roberts, like his hero John Marshall, about whom he talked extensively, recognized that to confront the president about the centerpiece of his domestic agenda right before an election would tar the court indelibly as a partisan body that would make his bipartisan aspirations impossible to achieve. By contrast, by playing like Marshall did the long game, by engaging in, Thomas Jefferson accused Marshall of twistifications, and that's exactly what Roberts did in this case. He avoids the conflict with Obama in the short term, but embraces a very narrow vision of Congress's commerce power that will both shore up judicial authority and restrict the regulatory state in the long run. I mean, you just couldn't have come up with a more subtle, shrewd, politically astute move that in the end did rebound to the court's institutional legitimacy. So I think, I mean, maybe I still have a man crush, but it was a sort of tour de force of leadership, and there's lots to say and to criticize it. We could talk about whether it's appropriate to take these pragmatic, or I won't say political, but more institutional concerns and to balance them against your view of the correct view of the law. But I mean, look, this is one interview. I've been milking it for all it's worth because I'm so interested in it. But I'm sort of impressed by the fact that the Chief Justice, at least at that moment, had a vision of the court. He wanted to talk about it and share it with the public. And then, although he certainly had mixed success in achieving it, and there were plenty of 5-4 decisions that didn't have to be decided along those lines, in the most defining case of his career, he actually did what he said. And I also understand, when I go back and read the interview, to some degree, why he was less successful in achieving that unanimity or avoiding partisan divisions in the other cases. Take Citizens United, for example. Jeff Toobin's book, The Oath, reports that Roberts had initially voted to decide the case on narrow grounds, the ones urged by Ted Olson, who said that the makers of the anti-Hillary Clinton documentary either shouldn't be covered by the campaign finance laws because they were a form of video on demand rather than broadcast video, or that they got so little corporate contributions that there should be an exception for them and they shouldn't be covered by McCain-Feingold. But it was Justice Kennedy who, in his usual fashion, wrote a sweeping, grand, majestic draft affirming the constitutional personhood of corporations and talking about their fundamental dignity and so forth. And then the other conservatives rallied around Kennedy, and Roberts faced a choice. He could refuse to join and, I guess, make it a plurality opinion and concur in the judgment, or he could sign on and write a kind of defensive concurrence, which he did, where he sort of peevishly said, it's not enough to be narrow, you also have to be right. But that just suggests, and Roberts acknowledged this in the interview too, that the success of a Chief Justice is going to be dependent not only on his own vision, but also on that of his colleagues. And to the degree that the swing justice prefers sweeping, broad, majestic, polarizing constitutional opinions, whether on the left or the right, to narrow statutory ones that avoid these kind of issues, then Roberts' task is going to be much harder. So that's the story of my interview with John Roberts. Now, whether I haven't talked to him since. Whether he would do it again, I don't know. I mean, some people read this interview, but it's not as if after the Affordable Care Act decision, a few of us, I and a few other journalists, remembered the interview and noted the consistency with what he said, but it didn't affect the public debate all that much. The conservatives denounced him for being craven and seeking favor with the Georgetown cocktail party set, which I don't think still exists, actually, by the way. I've been to Georgetown cocktail parties, but the Katharine Graham set does not hold any sway anymore. And liberals, I suppose, were kind of grudgingly grateful, but more like, oh, he'll, be against us the next time. So no real. The point is that there's not a political constituency for bipartisanship now. You don't get any points for being institutionally minded. You just anger partisans on both sides. So the idea of a Chief Justice trying to explain his vision and then having the public give him credit for it, I don't know how he'd feel about it. But anyway, I was honored to be able to hear all that, and for me, that's kind of an example of one form of Supreme Court journalism that I feel both lucky and fulfilled to be able to do. In a situation like that, it's not my role to say what I think. Who the heck cares what I think when you have the chance to sit down with the Chief Justice or any justice at length? The goal is to present them in their own terms, to ask questions that will make them feel comfortable enough to reveal the kind of justices that they want to be, both their philosophies and their personalities. And then others can judge, and I can judge in other contexts whether or not they're living up to those things. But that's the approach that I've taken in these other interviews. So that's my vision with John Roberts. I don't want to be like the boring uncle at the dinner party. How much? Couple more minutes, a couple more justices, a few little vignettes. I mean, Justice Ginsburg, Ruth Bader Ginsburg, was wonderfully sensitive to her boundaries. I'd known her before she was nominated and had written enthusiastically about her candidacy, and we actually bonded over opera when I was a law clerk, and she was coming down from exercising in the D.C. Yoga studio at the U.S. Court of Appeals, so that was the way that we met, and we sort of kept up ever since. But when I wrote about her for the New York Times Magazine, she was very careful about not being unguarded, and she's very good about her boundaries in public, although of course very warm in private. But she did let me, she said, go to my chambers and spend as much time there as you want and go look around. So I was in a rather awkward situation of, she greeted me warmly and said hello and then left. And I'm just sitting there in her beautiful chambers, kind of looking at the pictures of her and Scalia on the elephant, and her dressed as a Ruth in a performance of the Pirates of Penzance and so forth, and felt both the need as a journalist to record, but also not quite sure what I was supposed to do. And suddenly she called from the car as she was leaving and said that she wanted especially to be sure that I saw a picture of her son-in-law with her grandson, her infant grandson, whom he was holding. And at the time I thought, well, isn't that sweet? But it's a sort of banal thought about how, she said, that's my hope for the future. And I thought she meant, my hope for the future is her grandkids, as anyone's would be. But then I went back and started thinking more, and also started reading more of her speeches, and I saw a trope repeatedly where she said, the only time when women and men will achieve real equality is when men take equal responsibility with women for child rearing. That is my hope for the future. And the fact that her son-in-law had taken time off from his work to raise their grandson, for her, represented the core of women's equality. Wonderful insight, and it had to be decoded, and I really respect the fact that she knows her boundaries, and she presented herself. That was very important to her, but she wanted me to learn it that way and not just by sitting down, and I think she communicated that point very well indeed. Sometimes the revelations that justices make are inadvertent when they're trying to communicate with the public. I wrote about Justice O'Connor for the New York Times Magazine, and she was wary because I'd written critically about her, but she very kindly agreed to sit down with me, and we talked about books and Wallace Stegner, her favorite author, and we had a good conversation. But then I left to go, and I realized that I'd left the Stegner that I brought inside her office, in her chambers, because I'm an absent-minded professor, and I do that sort of thing all the time. So I went back into the office to get the book, and I saw that the cushion on which she'd been sitting, which had been concealed, had an embroidered motto, and it said, "Maybe in error, but never in doubt." And I thought that's so well summed up her jurisprudence, and it was kind of the great journalistic moment you're looking for. And then finally, I'll just say, Justice Stevens sat down for an extended interview for the New York Times Magazine about a year before his retirement, and I think he you know, he hadn't granted an interview for a long time, and he realized retirement was coming up, and there were some things that he wanted to communicate with the public, most notably the fact that he was frustrated by the fact that of all of the justices who had been appointed to the court after him, only one, Justice Ginsburg, could be said to be less conservative than her predecessor. Basically, all the others had been more conservative than their predecessors, and he thought that the court on which he sat and the Republicans with whom he originally sat would never have decided cases the way they were doing. He warned about the overturning of Roe v. Wade if the balance of the court shifted. I think there are things that he cared a whole lot about that he felt were imperiled, and he wanted to talk about that. And that seems like a perfectly legitimate way to use the press. So there's no big in conclusion, except I feel really lucky to have had these interviews. Each is different. Each were trying to achieve different things. The incentives for justices to sit down with particular journalists are obviously lessened at a time when they have direct access to the public. They can give interviews that go directly on C-SPAN. They can talk to whomever they liked and have that filmed and go directly on the web. So to the degree that they're concerned about the mediators, they don't need you know, the New Republic or the New York Times anymore. But I do still think, as an old-time interviewer, that there's a value to sitting down with someone who'll try to understand you sympathetically, put you in context, unite biography with some analysis of judicial philosophy. So I hope that the justices still continue to give some interviews, not too many, but mostly with me. Thank you so much.
Thank you. Our third speaker is my colleague, Christopher Schmidt.
All right, home stretch. You still with us? My motivating question is actually much the same as Jeff's. What are the justices trying to do when they go beyond their written opinion and speak to the public? Not having the first-hand experience talking to these justices, I'm going to use the tools that I know somewhat better, which is telling stories about history. So I'm going to start off with a story about a justice who had an interesting experience in terms of his role beyond the opinion as in his extrajudicial voice. And then I'm going to try and draw some general themes I think emerge from this and use this as a start-off discussion. The Justice Hugo Black. As a Supreme Court Justice, Hugo Black's relationship with the American people did not get off to a very good start. It was late summer 1937, and his colleagues in the Senate had just confirmed Black to the Supreme Court. Then the press picked up a story that early in his political life in Alabama, Black had been a member of the Ku Klux Klan. The resulting public outcry, editorial, appeared to imperil Black's continued place on the court. Black, who was in Europe at the time, cut his vacation short and came home to address the American people, and to do so through a nationally broadcast radio address. There's not a whole heck of a lot Black could say about this. He said what he could, which is that he had indeed been a member of the KKK, but was no longer, and that his record in the Senate, his personal relationship with blacks, Catholics, and Jews, showed that he was not a bigot. The speech actually was quite effective in turning the tide and in deflating this particular controversy. But predictably, perhaps, after this quite dramatic intervention in which he spoke to the American people, he sort of went into hiding. He did what Supreme Court justices would typically do, which is he started writing opinions. And he basically worked on the assumption that he was going to allow opinions to speak for themselves and was going to stay away from the public spotlight. Through the 1940s and the 1950s, as he defined for himself a very distinctive approach to constitutional interpretation, as well as a very distinctive voice, a voice that was particularly accessible in terms of how he wrote these opinions. He was often urged to present his views in more public settings, but he refused again and again. He said to a friend, "Should I conclude to deliver lectures anywhere," because again he had many invitations to deliver a formal lecture, "should I conclude to deliver lectures anywhere, it will be over the protest of certain inner voices that keep telling me that the best thing I can do is to tend to my knitting here at home." Eventually, however, Justice Black did accept one of these invitations, and in February of 1960, he delivered an address on the Bill of Rights at New York University. According to his biographer, one of the reasons Black overcame his reticence was an interest in finding a new place to expound his constitutional views, one that would not be in a form of a response to what other justices on the court were saying, one in which he could basically hold court himself and explain his views at more length. Although, ironically, if you read these lectures, he spent a lot of the lectures picking on an unnamed Judge X, who, of course, was Felix Frankfurter. So he still sort of recreated the straw man version of Felix Frankfurter in order to knock him down and then move on with what he was doing. Black's lecture was provocative, particularly his uncompromising insistence that, in his words, there are absolutes in the Bill of Rights and that they were put there on purpose by men who knew what those words meant and meant their prohibitions to be absolutes. His remarks were summarized in the national press and did spark a flurry of discussion within the legal community about Black's position. He gave occasional interviews and public lectures after that, but in the late 60s, he actually made a concerted effort to reach out again and try and speak in more direct ways beyond his opinion. This time, his time in the court was nearing an end, and he decided to take up an invitation to give a series of 3 lectures at Columbia University in 1968. His main motivation this time was somewhat more personal. He said that the main reason he finally decided to give these lectures, and the dean at Columbia had been bugging him for some time to do this, was that he wanted to defend himself. He had been accused by the late 1960s of changing his jurisprudence, of becoming more conservative. And he insisted again and again, to whoever was listening, that no, he actually, in fact, had stayed the same. So he wanted to defend himself against this conservative term. A number of people, he said, have been writing about my views in ways that cause me now to want to express those views myself. So he wanted his own words to come out. And these lectures, delivered in the spring of 1968, were quite well received and were soon published in a volume under the title, A Constitutional Faith. Now, by this point in his career, Justice Black seemed to have taken a liking to being a public figure. He agreed to be the very first justice to sit for a feature-length television interview. The interview was filmed at the justice's home study and aired in CBS in 1968. Black was initially reluctant when approached with the idea of this television interview. He worried whether such a forum was appropriate for a sitting justice, and he only agreed to the interview after talking to Chief Justice Warren as well as his friend Justice Black. Like I say, returning to Justice Black about propriety for a justice just strikes me as a strange place to go for proper judicial conduct. But they apparently signed off on this particular interview. This time around, he had additional motivations. He said that the main reason he wanted to take to the airwaves this time was because he wanted to protect the court. This was 1968. The court had become very politicized in the campaign. Basically, both George Wallace and Richard Nixon were running against not only Hubert Humphrey, but also the Warren Court. And he felt like the Warren Court and the court in general was being unfairly tarnished, and he wanted to stand up for that. Again, he hemmed and hawed, but in the end, the interview aired, and it made for very powerful television. And let me just play you a little clip, if I can get this going, which fortunately is on our very own Oye site. I don't have visuals, it's just audio.
I'm Eric Severide. On this street in the old city of Alexandria, Virginia, George Washington's town, stands the lovely old house of Hugo L. Black, Senior Justice of the Supreme Court of the United States.
But you felt it was your obligation to sustain them because they were constitutional.
I think it's my obligation to take this Constitution. I don't care what anybody else has decided. That's immaterial. Our system of government puts different people on the court. People with different views. I think it's their business to try to read these words, as silly as it may sound to some people. Some people have said that I'm either a knave or a fool, because if I was not dishonest, I couldn't say that they are absolutes. Well, I just don't agree with them. I think I can and do.
Mr. Justice, I would think you know the Constitution by heart at this time. Why do you always carry that little book of the Constitution?
Well, I don't know it by heart. I can't. My memory is not that good. When I say something about it, I want to quote it precisely. And so I use it, carry it in my pocket.
Do you think, Mr. Justice, that most Americans understand the Constitution?
No, I think most of them do not.
basically at that point just says he keeps getting letters from people complaining that he doesn't know the Constitution, and he doesn't appreciate that. When questioned about attacks on the court, first assistance protecting criminal defendants, Black went on the offensive. He said, well, the court didn't do that. The Constitution makers did it. They were the ones that put in every one of those amendments. They are complaining about the Constitution. And so when they say the court did it, that's just a little wrong. The Constitution did it. He suggested that the Supreme Court's implementation ruling in Brown with its all-deliberate speed formula was misguided, and that actually was the front page headline of the New York Times the following day. Brown questioning the implementation decision, Black questioning the implementation decision in Brown. And toward the end of the interview, he actually picked up a copy of U.S. reports and read from the end of his opinion in Chambers versus Florida, which has some very powerful language about the role of the court. Courts stand against any winds that blows havens of refuge for those who might otherwise suffer, and supposedly wiped a tear from his eye. So again, this was very powerful television that Black was creating here. Justice Black demonstrated remarkable skills, I would say, in these off-the-bench settings. In terms of communicating with the general audience, he drew upon his background as a quite adept trial attorney as well as a politician, as serving for a spokesperson for the court and expressing his deepest commitments about law and constitution in the court, and putting on display this sense of passion and commitment balanced with a sense of gravitas. He might well be unequal among the justices who have served on the court, certainly in a modern era. I do think he was able to sort of tap into something here. But I want to use Black's story not necessarily to focus on his distinctive ability to hold forth in these off-the-bench forums, but to use as a way to highlight some themes and patterns that would arise when justices venture beyond their opinions. But there's much in Black's story that I think is actually quite representative of the strange and often contradictory phenomenon of justices trying to speak directly to the American people. So this is good. What's going to follow in the next few minutes is just a few observations that I think Black's story helps to bring forward. One is that, the Black Pocket Constitution now has become sort of a fad or a rage. Everyone's picking out the Pocket Constitution. Diversity and motivation. So this is the main thing I'm going to talk about for a few minutes. Trying to figure out, well, why do justices go out and speak to the American people? Of course, the answer to that was lots of reasons to do it. And we find that even Justice Black's, the little snippet of biography that I gave about him, he had many different reasons for different journeys he took beyond his opinion. So I think it's possible to categorize them, at least to begin a discussion. If we want to think about this issue as something that's worth studying, I think is worth at least breaking it down into some basic categories and trying to figure out if there are problems or opportunities, what kinds of exercise of this extrajudicial voice are we talking about. One easy one would be a personal reason. All right. Oftentimes justices do talk in extrajudicial settings, do find that the opinions obviously are quite limiting when they talk about their personal stories. So, okay, Hugo Black famously, his radio address about the KKK was basically a personal story. We can see a lot of those books that are being published by Supreme Court justices, Sandra Day O'Connor's story about growing up on the Lazy V Ranch, Clarence Thompson's book, Not Have a Lot of Law, that had a lot of personal stories in it. Again, this is something. The reasons for why they might want to talk about these personal stories may be self-aggrandizing, they may be financial, as Jeff alluded to. They may be a belief that this is simply a story worth telling, and most often they're probably some mixture of all this. Now we can't move on from telling personal stories from the bench without talking about Justice William O. Douglas, who combined all these elements in his telling again and again and again of his own story. Justice Douglas is actually a fascinating figure to see as a justice who pushed beyond the boundaries of standard judicial practice. Early on in his career, he wanted to be president. So some of his early writings just actually had a feel of campaign literature. In 1948, he wrote a book titled Being an American. Right? It sounds like it could be a campaign story for a politician. Once he gave up his political aspirations, he turned his attention in part to women and got divorced 3 times, had 4 marriages. And this is actually significant because the subsequent alimony payments that he was stuck with left him chronically short of money, which drove him to write more and more books. He was a compulsive writer anyways, but really to produce book after book. And furthermore, Douglas actually had a quite remarkable story to tell about his life. And by some accounts, some of it was even true. The educational. All right, so another role we see justices playing, and this is goes way back in history. It's justices standing up to tell American people, to educate the American people. This is a justice as a sort of civics teacher. And I think Justice Breyer wrote his recent book in which, if you read the preface to the book, he said, my goal here is to communicate to the general audience and tell them about how the democracy and the court works. So you have Justice Black saying read the Constitution, Justice Scalia saying read the Constitution and the Federalist Papers. I mean, I think basically these are our efforts at civics education. And again, we have to bring in a topic that came up yesterday. Justice Sotomayor's visit to Sesame Street is basically an effort to reach out to kids and tell them about the role of judges in resolving disputes. And I guess she just went back on last week too, so she appears to be a new regular. But basically the goal here is to serve as an influential educator. Next one I'd say is institutional. All right, so justice is trying to protect the institution of the court. Chief justices in particular take up this mantle. So a lot of the chief justices off the bench presentations would fit into this category. One example I ran across was Justice William Brennan, who, like Justice Black, spent most of his time in the court not talking off the bench, just thinking, I don't want to talk to the press. He did occasionally make some forays out and make public statements. I mean, again, they always make public statements. We're talking about public statements that are actually interesting and have some content. One of the most interesting ones he made was in the late 1970s, where he railed against the press. And this is a theme. If you want to see justices sort of going off script, oftentimes the way that what will get them to do this will be frustration of the press, because the press is a normal conduit by which their opinions get to the people. But if they feel like the press are not accurately reporting, then they might feel they need to take this message more directly. So this was Justice Brennan taking issue with some press reports about a decision that didn't relate to press access to criminal proceedings. And he went after the journalists. He actually named a bunch of newspapers and a bunch of reporters and said, you just got this story wrong. The Washington Post ran an editorial titled, Justice Brennan Tells Off the Press, which is partly sympathetic, partly critical. And I will also say, oftentimes justices talk about the court is not as internally divisive as it might appear from the outside. I fit this in the category of protecting sort of institutional integrity. And then, of course, we have what we categorize as a jurisprudential. The justices who go out there to try and advocate their particular view of legal analysis and constitutional interpretation. And the leader in this camp today is certainly Justice Scalia, who again, has many different reasons for why he goes out, but a key theme does seem to be trying to promote his particular vision of constitutional interpretation. And Justice Breyer certainly joins him. And this is something I think that legal scholars pay particular attention to. So just of those categories, let me just conclude by identifying something of a tension that lies within this whole practice of extrajudicial speech. There is something quite powerful, potentially quite powerful, about a justice expressing his or her views on the court, on the Constitution, on the role of a judge in a democracy, or even on their own lives. A good deal of what the justices say in these matters are rather banal and uninteresting. Think of it sort of as a road tour for confirmation hearing talking points. But sometimes the justices do seem to be interested in doing something more, and it is here that news tends to be made. It's here that we find that whatever potential there might be for extrajudicial speech to add something distinctive to the discourse would lie. It's the very existence of the question of whether a justice should even be doing this kind of thing that gives these moments a kind of power. A risk of transgression? Anyone who listens to Justice Scalia, I think that's sort of in the air. Is he going to say something that sort of goes beyond the bounds, right? So that actually does make for a compelling engagement with an audience. It's when justices insist that complicated legal issues are actually not complicated at all, but can be resolved by common sense reasoning. This is Justice Black's classic maneuver. It's when justices find a way to connect their personal story with their judicial role. It's when justices show some emotion about their work, maybe even when they lash out at something. In these situations, justices step outside their expected roles. They act in ways that are basically political and personal. But it's also in these situations that we, the media, legal academics, and engaged citizens do tend to perk up our ears, and I think there are risks and possibilities in there. And on that point, I'm going to leave it. Thank you.
We have 15 or so minutes for questions. Jerry, you can start us off.
My question is for Jeff Rosen. You spoke with great emotion and about these interviews. Is there any plan to make them public?
Of course, the interviews themselves were published, and
I'm not talking about the transcripted version. but the audio version.
The audio version. Each has different arrangements. So the Stevens, I'd have to go back to them. But it's a good question, because when I heard Justice Black speaking, there's an incredible power to the voice. And thank you for the suggestion. Maybe it's worth doing. Now it may be too late, because I don't think they're going to go for it. But
would you rather read the libretto or listen to the opera?
Here. Yeah, you can do both at the same time. Yeah. Good idea.
Please.
I was wondering if various members of the panel could react to the show that Scalia and Breyer had together. So this is not just one justice going out, but two together, and they tell jokes and finish each other's punchlines. And what's that? I mean, does that fit in the category, or is that just another category? And it reminds me of Jason a little bit. Kind of seems like they have a little tag team in front of the Senate. So is this a new emerging form where they go out with a buddy system? Or?
Just a few words on that, and please jump in. It does strike me if you're trying to fit in some sort of category. It's just the mere fact that two justices who tend to be on opposing sides of the ideological spectrum standing up there together and engaging, I think, is a visual display of some sort of institutional integrity kind of point. And then clearly, the point of those shows tends to be hashing out differences about constitutional interpretation. I'm generally in favor of this, and I think those were quite effective at getting the issues out there in a very again, the challenge is to be to give the law the complexity of the law, the respect that they deserve. The knowledge of the complexity of the law, while still making it engaging for broader publics, and the dialogue, debate, sort of format, I think, can serve that pretty well.
I don't remember all the details, but did they both have books to sell at that point?
Yeah. So.
Yeah, my question is for Jeff Rosen. So I'm thinking about the extent to which Chief Justice Roberts might be able to carve out a little bit of self-power for himself to achieve his goals in light of the Affordable Care Act decision, where he can carve out a niche for himself as the swing vote. And what's hovering in the back of my mind is Nancy Levity's work when she's discussing Justice O'Connor, referring to that as the Queen's Court. So I just wondered if you had any thoughts about that.
It's a great question, and I'm sure that Roberts enjoyed the fact that for the first time since his Chief Justiceship, it actually became not the Kennedy Court, but the Roberts Court. But it seems like his ability to do this, unlike O'Connor, there was flexibility in the middle with O'Connor and less with Kennedy. So O'Connor found it easy to go back and forth because Kennedy would occasionally do so too. Given the fact that Kennedy rarely goes back and forth, and Roberts doesn't either, his ability to play this role is limited to the very, very few cases where he's willing to alone among the conservatives break ranks. And there don't seem to be many of those cases, and they go against his grain. He told me when we talked, it's not that he planned to compromise because he had views, strong views. What he wanted to do, his original vision was not that he'd be the fifth vote for the liberals, that he would persuade both the liberals and the conservatives to avoid broad constitutional rulings and to converge around narrow, unanimous opinions written by him. And that goal, I think, turned out to be just overly ambitious. It was sort of like President Barack Obama, who came to Washington expecting to be a uniter and not a divider, and found the divisions were much more entrenched. And Roberts may have overestimated his own ability to persuade people to come around to his point of view without compromising on his own. And he'd done that at the DC Circuit too, so I'm sure that he very much enjoys having it be his court, but it sounds like his ability to pull the particular maneuver that he did in the ACA case is limited to cases where he's willing, in cases where Kennedy is with the other conservatives, to join the liberals. Now, if he and Kennedy could form the alliance that O'Connor and Kennedy did, that would be different, but as we saw in the ACA case, according to Jan Greenberg's reporting and others, when Kennedy's made up his mind, he's obdurate. I mean, he's Mr. Justice Hamlet when he's deciding which way to go, and has a whiteboard where he sketches decisions on both sides and tries the positions on like hats. And once he's made up his mind, he won't budge. So it sounds like he's less willing to play that role for Roberts than O'Connor was for Kennedy.
Yes.
The case that might be closer to the Roberts model that you presented to you would be the Northwest Austin case, where it was a possibility that this would strike down Section 5 of the Voting Rights Act as unconstitutional. And instead, they took a statutory interpretation that was totally implausible, really, and did not strike it down, but let Northwest Austin bail out. I'm wondering whether that case and the ACA are really not more connected. And going back historically, really didn't Roberts try to pull a Chief Justice Marshall in the ACA case? He articulated two broad principles about the Commerce Clause and about commandeering, and then caught something else to keep the legitimacy of the court. The possibility of striking down the Voting Rights Act comes up again in Texas v. Holder, which is the case in Texas where they proposed a voter ID law and a 3-judge panel struck it down as unconstitutional. Now it's going to be appealed to the Supreme Court. Here's Roberts' next chance to strike it down. How would you and the other panelists read this?
Great question. I think the Namundo case is exactly the right one to ask about because it's the most dramatic example, as you say, before the ACA of Roberts coming up with a completely implausible twistification to save the act. I can say it's completely implausible because, boasting alert here, my brother-in-law was the deputy SG who argued the case, and Neil Katyal, and that idea that the utility district could opt out of coverage didn't occur to him or to the government or to any of the parties. It was invented by Roberts in order to avoid a 5-4 split. Now, at the time, I thought that this was a great example of Roberts doing just what he said, and that he deserved. Lyndon, I think, talked about this, that he deserved. Lyndon was less convinced that he deserved credit for, having stopped the court from going off the bridge. And later reporting, I think, confirmed Linda's skepticism more than my initial optimism, because apparently Kennedy actually, originally Roberts was prepared to strike down the Voting Rights Act, but then Kennedy got cold feet and was either going to switch his vote or write a narrower concurrence, and faced with the possibility of a 5-4 split, and the liberals making clear that they were going to make a big fuss. At that point, Roberts decided it was better to avoid the constitutional question and make up this opt-out, and he got everyone except for Thomas to go along. So if that's the case, he did it under duress then, and it seems less likely that he can come up with a similar saving construction this time, because the Namundo decision was pretty clear to Congress that it had a short period of time to fix this, and Congress did not respond at all. So for a judge who believes, as Roberts and the other conservatives tend to, appear to believe that in its current formation, the Voting Rights Act violates the Equal Protection Clause, I don't think they're going to pull that out again.
Actually, the three cases that you mentioned, the Affordable Care Act case, the case of the Voting Rights case from a couple of years ago that's now back, and also the ACA case, have a sort of similarity in the sense that there's an issue, I think, in all of those cases that has to go to the court issuing some kind of warning to the legislature about what's coming down the road. And so we know that from the affirmative action cases, right? O'Connor built in this sort of time limit, which was maybe getting too faster than she said, but there was always the sense that this isn't going to go on forever. In the voting rights case, same thing, Congress, you better fix this because next time around it's going to go down. And you might understand also Robert's vote in the Affordable Care Act on the Commerce Clause issue, but upholding it on the tax ground in the same way, right? Don't invalidate the whole statute based on this activity and activity distinction that's never been announced before. But Congress, next time that comes around, I'm not going to be so willing to save the statute through this other sort of reading. So in some ways, there is a sort of dialogue that's going on represented by those three cases.
Chris, this question is for you. Observing the Supreme Court nowadays, who the Chief Justice is sort of sets the tone for how much communication justices can have outside of their opinions. And this was especially true when I watched the Rehnquist court. So I wonder with Black, with Chief Justice Warren, what kind of tone he set for how much extra communication there could be outside of the opinions. And also whether Black, I don't know if he had any period of retirement, but today, justices in retirement seem to speak out a great deal. I don't know if we had retirement, if we see more activity there as we do today.
Yeah, Black, as I recall, had a very short retirement and very failing health, so I don't think it should be active. The whole phenomenon of public lives of retired justices is fascinating. I think it's sort of a topic unto itself. In terms of Chief Justice setting the tone, I think that's an interesting issue here. I mean, clearly, Chief Justice Earl Warren was engaged, but most of his extrajudicial engagement was more the sort of pro forma, speaking of the court in more general terms. He certainly didn't engage with any specific judicial philosophy or even referencing cases in the way that Justice Black did, or Justice Douglas was doing the same kind of thing. It is an interesting phenomenon with Chief Justice Warren, because he came into a court in which he has some very powerful established figures already there. So I think his ability to actually lull them and affect them would just be difficult. He felt self-conscious about his lack of judicial training. He actually he allowed Justice Black to run the conference for a short period of time as he's sort of getting things going, and deferred to him. Justice Black gave him some classical Roman literature to read. I think that was what he helped him out with, Aristotle. So I think it depends on the personalities, and just looking at the particular case that I looked at, Justice Black clearly talked to Chief Justice Warren. I just don't see Chief Justice Warren being able to herd in this particular group of people when you have people like Frankfurt, Douglas, Black doing what they want to do.
Linda, and then Steve, and that'll probably be the end of our time.
Yeah, just to follow up on Jason's comment about the court sending signals to Congress. So I wonder, in your study of the justices testifying before the appropriations subcommittees, whether you're also looking at the court as the judicial conference interacting with Congress. So, for instance, with the Violence Against Women Act case, Morrison's, the judicial conference had taken an official position opposing the statute on the grounds of too much work for the federal courts. So that was the kind of framework within which the testifying justices, they were just reflecting what already, I mean, they weren't off on their own frolic, in other words. So it would just be interesting to track, Judith Resnick has done a lot of this work, to track the kind of separation of powers questions growing out of the court basically telling Congress what kind of legislation to pass. And certainly the Chief Justice Rehnquist's various plays on habeas stuff is richly fascinating on that.
Yeah, and then the other sort of related piece is the annual reports from the Chief Justice. Some of that has stuff that gets echoed in the testimony that comes the next year. But at other times they distance themselves from that and say, well, it's not my view, but here's what I think. I think you're right that there are these other sources that may or may not be reflected in the testimony. It's a very good suggestion. Thank you.
Chris, I wanted to ask whether you think that one motivation for these public statements is ever to sort of appeal over the heads of the court to the public, and you know, so maybe to try to bring public opinion to bear on the court or whatever. In the case of Black, for example, his view about absolutes was always very much a minority. Douglas sort of, agreed with him, but pretty much nobody else. And Scalia's, sort of originalism is not something that most of the justices support, at least in a strong way. Maybe Breyer sort of feels like his pragmatism is on the defensive right now. So, I mean, do you think that's ever part of what these justices are trying to do?
I think that's absolutely the case. Although this does raise to mind something that I work out a little bit more in the written piece, and that is what makes for the effective use of this particular language, because it's different than what works well, I think, in a written opinion. Although there's always a question of audience, but if we assume this gets back to our journalists, right? There's a general audience here, and how which justices are better and which are less effective at speaking to the general audience. What works well in this general audience context? It did seem like Justice Black seemed to have a certain power, and I think partly by virtue of his simplicity. In fact, I'm going to quote my co-panelists here. In a book review you wrote, Justice Black's biography, you described Justice Black's tendency to use italics instead of argumentation, right? Rather than laying out some long, involved argument, he just says, this is the way it is, and really insists upon it, and then says it again, and moves on. But this actually can be quite effective in the correct setting. And I would put Justice Scalia as sort of someone else in that category who I think is quite effective. Effective beyond the compelling nature of the argument he actually makes. So then the question is, why is he particularly good at sort of grasping the audience and working with them? It's a sense of humor, it's a sort of the simplicity of the argument he offers, which I think, for example, Justice Breyer, who's also quite active, just has more difficulties. And I remember hearing Justice Breyer on a radio interview said, and he said what everyone knows, which is, my way of interpreting the Constitution does not fit on a bumper sticker. By implication, the other guy sort of does. I think they're absolutely trying to go to people, and then the question is what works and what doesn't work in that setting, how you try and convey that. Is the part going to be effective? By how effective you think you're going to be at getting that message out?
Do any of my panelists have any last words of wisdom to share with us before we adjourn? Thank you very much.
This is the end of our day. I just want to say thank you to everyone who traveled from near and far for coming here. It's been a great day. I appreciate it. So thank you very much.